We are anonymous. We are legion. We do not forgive. We do not forget. Expect us. The unseen threat, indefinite detention in our liberties. Friends, colleagues, fellow citizens. We gather today to discuss a critical, yet often overlooked, threat to our fundamental liberties, the provisions for indefinite detention embedded within the National Defense Authorization Act, specifically those originating from the 2012 fiscal year. While the NDAA is primarily a military spending bill, buried within its complex language are sections that raise profound questions about who can be detained, how, and for how long, questions that strike at the very heart of American due process and civil rights. The research before us highlights sections 1021 and 1022 of the FY 2012 NDAA. These sections emerged from the post-9/11 landscape, ostensibly to codify the authority to detain individuals involved in terrorism under the laws of war, an authority previously asserted under the broad 2001 Authorization for Use of Military Force, or AUMF. But the controversy, then and now, lies in the details, or rather, the lack thereof. The most alarming aspect, and the focus of our concern today, is the potential application of this authority to U.S. citizens, particularly those apprehended right here within the United States. While Section 1021 includes a disclaimer stating it shouldn't be construed to affect existing law or authorities relating to the detention of United States citizens, captured or arrested in the United States, this language is a source of dangerous ambiguity. As our research points out, existing law on this matter is far from settled. Landmark Supreme Court cases like Hamdi v. Rumsfeld addressed citizens captured abroad, while the Padilla case, involving a citizen arrested domestically, was dismissed on technical grounds, leaving the core question of domestic military detention authority for citizens unanswered by the highest court. Critics argue, convincingly, that this disclaimer in Section 1021(e) doesn't protect citizens, it merely preserves a contested and potentially expansive interpretation of the AUMF that a future administration could exploit. Compounding this risk is the vague and undefined language used to describe who can be detained. Section 1021 refers to individuals who were part of or substantially supported Al-Qaeda, the Taliban, or associated forces. Terms like substantially supported and associated forces are not statutorily defined. This vagueness creates a chilling effect. As the Hedges v. Obama lawsuit demonstrated, journalists, academics, humanitarian aid workers, and others whose work might bring them into contact with certain groups fear that legitimate, even constitutionally protected, activities could be misconstrued as substantial support. The lack of a clear requirement for knowing or intentional support in the statute only deepens this fear. The Hedges case, brought by journalists and activists, sought to challenge this vagueness and the potential for detention based on their work. But the courts, in the end, avoided ruling on the constitutional merits, finding that the plaintiffs lacked standing because they couldn't prove a sufficiently imminent threat of detention. This leaves the legal landscape uncertain and means, as some feared, that one might only gain standing to challenge the law upon being detained, at which point, access to legal recourse could be severely limited. While past administrations have stated policies against the indefinite military detention of citizens without trial, and while these specific NDAA authorities haven't been widely invoked for such purposes publicly, the statutory language remains on the books. It is unrepealed and, crucially, open to interpretation by future leaders. This is where the specter of the worst-case scenario emerges. Imagine a future administration, perhaps one less constrained by norms or more aggressive in its interpretation of executive power, choosing to leverage these latent authorities. In a worst-case scenario, the ambiguities and vagueness of the NDAA could be weaponized. Indefinite detention without charge or trial, citizens could be detained indefinitely based on suspicion, labeled as covered persons under a broad interpretation of substantially supported or associated forces, without ever being charged with a crime or facing a jury in a civilian court. Erosion of due process and habeas corpus. the fundamental right to challenge one's detention before a neutral judge, the writ of habeas corpus, could be undermined. The due process rights guaranteed by the Fifth Amendment, including the right to notice of charges and a fair hearing, could be severely curtailed in a military detention framework. Chilling effects on free speech and association. The fear of being labeled a covered person based on vague criteria could silence dissent, stifle investigative journalism, and discourage legitimate contact with controversial groups, thereby chilling the vital First Amendment rights to free speech and association. Blurring of military and domestic law enforcement. The potential for military detention authority to be applied domestically risks blurring the lines between the military's role in foreign conflicts and law enforcement's role at home, potentially undermining foundational principles like the Posse Comitatus Act. These are not merely theoretical concerns. They are potential consequences rooted in the unresolved legal ambiguities of existing law. The NDAA FY 2012, in its attempt to codify detention authority, inadvertently, or perhaps deliberately, left the door open to interpretations that could profoundly impact the rights of American citizens. The fact that these provisions remain on the books, despite years of criticism and attempts at repeal, means the threat persists. A future administration, unbound by the stated policies of its predecessors, could attempt to give these dormant authorities life, with devastating consequences for civil liberties. We must remain vigilant. We must understand the potential power codified in these laws and advocate for their repeal or significant amendment to explicitly protect U.S. citizens from indefinite military detention without charge or trial, particularly within our own borders. Our constitutional rights are not granted by any president or any administration, they are inherent, and we must be prepared to defend them against any potential overreach, now and in the future. Thank you.